Hi, I'm John Hanson, the managing attorney of the American law firm. And what you're about to view is a short video on frequently asked questions about child custody. Now, this issue is extremely sensitive and vitally important in any family law case. It's crucial that you meet with an experienced attorney such as those at our firm before you make decisions that may affect your children. If you or anyone you know needs representation for a child custody case, call the American law firm at 815-394-1776 for a free consultation to talk about the issues in your particular case. Our attorneys have decades of experience that may help you navigate through the court system and reach your goals. In an Illinois divorce case or in a non-divorce paternity case, there are two forms of custody referred to. First, there's legal custody, which refers to the decision-making power of the parent and which usually is held jointly between both parents. And second, there's physical custody, which refers to the parent who takes care of the kids at their house a majority of time during the week. In other words, the parent who usually does the cooking and the cleaning and the putting to bed chores for the kids each day. Now, physical custody is also called residential custody. Joint legal custody refers to the right of both parents to determine together the child's educational, health care, and religious training, among other major decisions. It does not mean that the child spends equal time residing with both parents. That's joint physical custody, which is not common. Now, some people mix up these terms when talking about their legal cases, and it's important to keep legal and physical custody powers separate in your mind when discussing these issues. Contact our firm at 815-394-1776 if you have any questions on this crucial issue. Sole legal custody refers to the right of just one parent to determine by him or herself the child's educational, health care, and religious training, among other major decisions. The parent with sole custody also has sole physical custody. A parent can have this form of custody if it can be shown that the other parent is unfit to have any custody whatsoever, or if the other parent has abandoned the children for a long period of time, or if the other parent simply agreed to give up their custody rights. The best interest of the child is a legal standard used by the court to determine child custody. To determine the child's best interest, the relevant statute requires that the court consider all relevant factors, which includes the following things: the wishes of the parents, the wishes of the child depending on the child's age, maturity, and education, the interaction of the child with the parents, the siblings, and other relevant persons, the child's adjustment to home, school, and the community, the mental and physical health of all the parties involved, including the parents, any acts of violence or threats of violence by the parties, and the willingness and ability of each parent to encourage a close and continuing relationship between the other parent and the child. It's vital that you have an experienced attorney fighting for you to get the proper arrangement of custody rights. The attorneys at the American law firm have decades of experience that can help you reach your goals. Contact us as soon as possible to get started. Custody fights are notorious for being costly both emotionally and financially. They may cost thousands of dollars, and they may involve emotional anguish, and they often diminish the ability of both parents to cooperate to raise healthy and happy children. Now, that being said, a parent must push for what they believe to be the best custody arrangement for their children, and the courts have a system in place to address those concerns. Now, generally, parents who disagree on custody and visitation will be sent to mediation first to see if it's possible to work out an agreement. Mediation happens before a trained mediator who hears each party's concerns and attempts to reach an agreement. If mediation is unsuccessful, the court may appoint an attorney as the attorney for the minor children, called the GAL, or the guardian ad litem, which is the child's representative. If no agreement is reached, custody experts may be retained. A party may not move to modify a custody judgment within 2 years of its entry unless the court permits the party to do so The party has to show that there is a reason to believe that the child's present environment may endanger seriously the child's physical, mental, moral, or emotional health. Now, to prevail in a petition to modify custody, whether such a petition is filed within 2 years of the original judgment or later, the petitioner must prove two things. First, that there is a change in circumstances with regard to either the child or the custodian since the custody judgment was entered, or material facts have come to light that were unknown at the time of the custody judgment, and modification is necessary to serve the best interest of the child. Child custody decisions are extremely emotional and complex, as you can see. And the more information you have up front about the child custody process, the better equipped you'll be to handle these substantive issues. You'll find more information about custody and about family law in general on our website, theamericanlawfirm.com. Also, call our office at 815-394-1776 for a free consultation to discuss your particular legal issues with our attorneys.